So my name is Dustin Salariaga, and I'm an associate at Scott Legal PC. If you're here today, you might already have an E2 visa. You might know a little about E2 visas or a lot, and all of you are welcome to be here with us, and you're in the right place. Our firm was actually founded on an E2 visa about 10 years ago, so we have a wealth of personal experience navigating the process. Our firm does have a focus on investor visas, and we've processed hundreds of them. Today, we'll be covering the fundamentals of the E2 visa, including the underlying requirements, as well as what goes into a strong renewal application. A few things before we get started. This webinar is part of a series that we'll continue by doing at least 2 webinars a month. And these are on a variety of immigration topics. We already have a number of webinars scheduled, and we'll be adding more regularly, so please do check back. At the end of this webinar, we'll send out a few things. We'll send out the PowerPoint of the presentation, which you see on your screen now. We'll also send a link where you can sign up for the additional webinars that I mentioned before. And since this webinar is being recorded, we'll send you a link where you can view the recording. We do post our webinars to our YouTube channel, so please do visit our channel to see this webinar as well as our past webinars and shorter videos on a variety of immigration topics. Just to note, we not only handle business immigration cases, we do family immigration as well and humanitarian immigration. So really any immigration issues that come up for you or your contacts, please don't hesitate to reach out to us for help. A few housekeeping items before we get started. We do plan to reserve a few minutes at the end of the presentation for questions, but if the question is especially relevant to what we're talking about, we may take it during the presentation. To send in a question, please send it to me through the Q&A function on Zoom or through the chat box. I'll be monitoring both, so either are fine. Again, my name is Dustin. I'll be the moderator for this webinar, and we are very fortunate to be joined by Michaela Vrazdova, who is my colleague and a fellow associate at the firm. She will be handling the second half of the presentation to go in depth into a number of topics and some recent developments regarding the E2 visa. Michaela has a wealth of experience and has personally prepared and filed many E2 visa applications. So we're very fortunate to have her speak with us today. So with that, let's dive into the E2 visa's rules and regulations. The E2 visa is a non-immigrant visa that allows nationals of certain countries to come to the US to develop and direct the operations of an enterprise in which they have invested. We will go into detail on a number of the pieces that I mentioned in that sentence, which actually has a lot in it. There are a number of options for obtaining an E2 visa. The most common 3 options are that the applicant can purchase an existing business in the United States, the applicant can start their own business in the United States from scratch, or the applicant can start a franchise and work with a franchisor to open a location in the United States. We see all 3. We'll talk about each as we get into more detail on the various requirements for the E2 visas. A fundamental requirement here, the 3rd bullet on your screen, is that there must be a treaty between the United States and the country of which the applicant is a citizen. So as I mentioned before, the E2 visa is a treaty investor visa. So what that means is that the individual who's applying for the E2 visa, they need to have a passport from a country that has a treaty with the US, an E2 treaty. To check the list of E2 treaty countries, there are currently about 80 countries, and they really are around the world. So odds are that your country is on the list. However, there are some countries that are not on the list, including China and India and Brazil, a number of countries with extremely large populations. Basically, what we do see is that individuals who are citizens of, say, China or India, some of them do choose to receive citizenship through investment through a country such as Grenada, which is an E2 treaty country. So there are pathways for individuals who are not born in an E2 treaty country to actually get the necessary citizenship to apply for an E2 visa. And that actually is not uncommon for a person to follow that path. For the E2 visa nationality, it is, again, not necessary to be born in an E2 treaty country, only that you have a passport from an E2 treaty country. So for how long is an E2 visa valid? The range of time is between 3 months and 5 years. For many visas, there is something called reciprocity. And so the US government will actually limit the period of the visa's validity depending on the reciprocity, the period that the partner country, the home country, offers to US citizens who are applying for a similar visa. So the range really does vary from 3 months to 5 years. The maximum is 5 years. And that is published on the US Department of State's website as well. If you want to check, you can Google E2 visa reciprocity, and you would select your country of nationality and see a list of the validity periods for each visa type. So let's go into a little more detail on the E2 visa requirements. You see the main ones on your screen now. The first is what we talked about before. You must be a national of a treaty country. Again, that means you have a passport from a treaty country, not that you were born in a treaty country. Being born in a specific country is relevant if you're applying for a green card. And you may have noticed on the previous slide that the E2 visa is a non-immigrant visa. What that means is that the E2 visa is not a green card. It does not lead to permanent residence. You do, as part of the application, you'll see, we'll speak about this more later, you need to sign a statement saying that you intend to leave the United States at the end of your E2 status. Now, that being said, if it is possible for someone who holds an E2 visa or is in the US or in E2 status to apply for a green card. They may become eligible for a green card and apply for one. So there are things to be aware of if you're navigating that process or want to navigate that process. But point being, it is not impossible to pursue a green card if you are on an E2 visa. Only know that an E2 visa is not necessarily, in the eyes of the government, is not a stepping stone to permanent residency. The second requirement is that you must make an investment. The applicant must make an investment. This means that the applicant actually needs to put their own personal funds at risk, to make their funds at risk. The money has to actually be spent on the E2 business. In other words, it's not sufficient for the applicant to put funds into a business bank account and use that as evidence of committed funds. What the government would say in that case is that the funds are not actually committed. The applicant can simply move the funds out of the bank account and back to their personal account. It is possible, if you have committed funds to the business, so you've spent funds, it is possible to still have working capital. So those funds that are in a business bank account, it's fine to show that you have funds available. However, you can't rely on those funds alone. Just to take an example, if an applicant put $1 million of their personal funds into a business bank account and applied solely based on that working capital, that application would very likely be denied. It should be denied because the funds are not actually committed to the business. However, if the person spent 500,000 of that $1 million on the business, they could show then that they have an additional $500,000 reserved as working capital, and the government would like to see that. It's good to show that there really are concrete plans to expand the business and funds available for that. But the takeaway here is that the funds actually do need to be spent in order to qualify and satisfy this requirement that a substantial amount be invested in the business. The source of the funds is also a key part of an E2 application. The consulate or USCIS will look at where the funds invested in the business came from. Their question is whether the funds came from a legal and legitimate source. So, there really is a broad scope of options here. And in many ways, it's easier to talk about what's not allowed rather than what is allowed. What's not allowed is obviously any funds that were acquired through illegal or illegitimate means. Also not allowed is any loan that is secured by the E2 business or its assets. So the funds actually do need to be personal funds. It's fine to use a loan as long as it is secured by the personal assets of the applicant. But things that are allowed, personal savings. So if you receive money through work, investments, if you receive money through a gift is fine, and really a gift from anyone is fine for the most part. You would want to document the gift. And you would also need to provide evidence of where the person giving the gift got the money. So if they received the money through their own work, then they'd need to document that. It's fine to receive funds through the sale of property, such as a house or an apartment. And as I mentioned before, a loan is also acceptable as long as it's not secured by the assets of the business. One other source of funds that frequently comes up and can be problematic is if the business is operational and the source of funds is business revenues, so revenues from the E2 business itself, or the business that you're applying for the E2 visa through. The government will not consider business revenues that are retained by the E2 business as a legitimate source of funds. So if you do have a business, whether it's the E2 business or a separate business that's unrelated to the business you're applying for the E2 visa for, then what you'd want to do is distribute those earnings to yourself as the applicant. You would want to show that you paid taxes on those distributions, and then that you use those funds to invest into the E2 business. So that's okay. That is essentially converting retained earnings into personal funds that you're then investing into the business, and that is an appropriate way to do that. We'll talk more about what a substantial investment amount is, which is one of the most common questions we receive. Typical E2 expenditures, you see a list on your screen. Really, it's helpful to take a step back and ask what this substantial investment amount is all about. There are really two things the government's looking for in a substantial investment amount. The first is the government looks at the overall investment amount as a sign or a signal of the applicant's commitment to the business. This doesn't necessarily make sense from a business perspective. Oftentimes it's possible and even wise to build a business that is streamlined, right? That doesn't have a lot of overhead. That's not how the government sees it. The government wants to see that you've really put a good amount of funds into the business, and they see this as a signal of one's commitment to the business. The second thing they're looking for, though, in the investment amount is to see that the applicant has spent money on all of the things that are necessary to get the business operational. And we'll talk about the real and operating requirement in a moment, but basically the investment requirement is an opportunity to show the government that you really have bought everything you need to get the business operational, where the only thing necessary is that visa. And as soon as you get the visa, you're going to come to the US and start operating the business, generating revenues and employing US workers. So some typical E2 expenditures are inventory if the business requires it, equipment, office equipment, or equipment to create the product or service that you're selling, spending money on a website, marketing activities, business premises. This is very important. It's not a strict requirement, but it is wise to show the government that you have office space and you've actually executed a commercial lease and made payments on that lease. So you have space not only to do the business, to operate the business, but also to hire workers. And finally, it's fine to include fees that you pay to set up the business, legal fees, etc. You see a note here, investment when starting versus purchasing a business. One thing to keep in mind is that when you're purchasing a business, a suitable value, and we'll talk more about this in the next slide, is the amount paid for the business on the open market. You see there on the screen the word escrow. So understandably, a lot of visa applicants are hesitant about spending a large sum of money on a business that is dependent on the issuance of a visa. If the government decides not to issue the visa, you may be out a good amount of money. So an escrow account, an escrow contract could be a good option, and really is the only option that the government will accept to provide a protection if your visa is not issued. So what an escrow agreement says is essentially that the investment amount is in an escrow account, and the sole contingency, the only thing that needs to happen for those funds to be released, is issuance of the visa. And as soon as the visa is issued, the funds that are held in that escrow account are released. The government will accept that as committed funds, but that really is the only exception where funds that are not technically committed are considered committed by the government. Now, obviously, given the nature of an escrow agreement, this typically only makes sense if you're purchasing a business in the US, starting a franchise or a franchise location in the US, or really buying a business asset for a startup where the asset is significant. And the reason for that is you really, an escrow agreement's a contract. And so, it has to be between you as the person buying something, whether that be a business or a franchise, and the person selling that thing. So if you're starting a business, you have a lot of smaller expenses, relatively smaller expenses, versus buying a business where you have one big expense. An escrow agreement makes sense where you have one or two big expenses. So the third requirement that you see on your screen is actually a really key requirement. The business cannot be marginal. What that means is that the business needs to generate sufficient revenue to support not only the applicant and their family, but also US workers. What the government tends to look for, and what we generally recommend, is that the business needs to show that it will hire between 3 and 5 US workers, full-time equivalent US workers, within 5 years of starting operations. Full-time equivalent means that they can be part-time, but full-time is 35 hours a week. So if you have 2 part-time workers, their hours need to add up to 35 to be considered one full-time worker. Again, this is a key requirement, and the thing to keep in mind about this requirement is it really can make or break an application. So if the government is not convinced that the business will employ US workers, there's a very good chance that you'll be denied. On the other hand, if your application is relatively weak, for example, if you have a lower investment amount, you can compensate for that by showing that you've already hired one or preferably more US workers. So just to take an example, I prepared an application not too long ago for an individual starting a software company, which required very little money to get started. He hadn't invested much. And so what we ended up doing was showing that he had employed workers, was already employing workers, because the business was generating sufficient revenue to employ workers. And that showed that even though he hadn't invested a large amount, he had invested enough to get the business operating to a point where he was employing workers. And by showing that, he satisfied the government, and they issued him the visa. The next requirement you see is that the business must be real and operating. I referred to this before. Essentially, the visa needs to be the last thing standing in the way of the business generating revenue and starting to employ workers. So if you show up at the consulate, for example, and you're applying for an E2 visa, look for business opportunities, you'll be denied. The E2 visa is not a visa that's meant to search for opportunities or set up the business. That all needs to have been done before you apply for the E2 visa. If you need to come to the US to do those things, the B1 visa is suitable, as is ESTA if you live in a visa waiver program country. The government will look for certain evidence showing that the business is real and operating or ready to be operational as soon as the visa is issued. Examples are a signed commercial lease, evidence that the business entity has been established, evidence that the company has a website and is already marketing its products or services. It's great if you have contracts with customers, so people who are interested in hiring you, we would often recommend that you include those contracts or even letters of intent to do business with you in the application. And any business licenses that are required, you'd want to tell the government that you have those. So for example, if you're starting a restaurant, in Vermont, you'd want to show that you have the necessary license from the health department, the state's health department, showing that you've been vetted, and as soon as you get the visa, you have authorization to start operating that restaurant. The next requirement you see on your screen is that the applicant must solely develop and direct the E2 enterprise. You need to be qualified to operate the E2 enterprise. This is not an educational requirement necessarily, but you do want to show in your application that you have the background, the experience, if it is education, then the education to run the business that you plan to run. And this is really an opportunity to advocate for yourself. You really are in your application, really trying to convince the government that you're the best person to do the job and operating this business. Also, an E2 visa enables the applicant to come to the US to work for the E2 business, not to work for any other employers. So that is important as well, that you want to show that you are coming to the US to do this, that your job will be to develop and direct the business. The other aspect of this requirement that's very important to keep in mind, especially if you're applying within the US through USCIS, is that you should not be the person who's providing direct services to customers. And this is what I mean by that. It may be helpful to talk about an example. Let's say that you are an accountant and you want to start an accounting firm in the US. If you're applying for E2 status through USCIS to start this accounting firm, and you show that you project in your business plan, for example, that you will be the only person working there for the first 2 or 3 years, and you'll hire employee number 2 in year 4, and you'll have 5 employees by year 5, but for 2 or 3 years, it really is just going to be you. That is a risky application. And the reason is that the government would say that you are actually applying for an E2 visa to work as an accountant. Which is arguably, in the eyes of the government, taking away a job opportunity from an accountant in the US who could do that work. Contrast that to someone who is applying to start that accounting business, who is saying, I am going to develop an accounting firm. I am not primarily going to be an accountant for clients. I'm going to be looking at the profits. I'm going to be marketing the business, going to conferences, networking, and I'm going to hire someone who is in the US, able to work, who's going to work as the accountant, even part-time. That is going to be a much stronger application because the government, again, wants to see that the applicant is developing and directing the E2 enterprise and is not the person that is primarily providing direct services to clients. One of the other threshold requirements, you see this at point 6 on the screen, is that you must own at least 50% of the E2 company as the E2 investor. So the moment that your ownership stake drops below 50%, you become ineligible for E2 status, and that is automatic. So you need to be very careful that you have at least 50% ownership in the business. This also means, though, that you can have co-owners. So it is possible for two E2 investors to apply for E2 visas. They have to both own 50% of the business, but that is an option. You must finally have the intent to return to your home country upon the expiration of your E2 visa or status. As I mentioned before, the E2 visa is a non-immigrant visa. It's not a green card and does not lead to a green card. And so the government does want to see that you plan to leave the US at the end of your status. This is actually usually a very easy requirement to satisfy. What we would include is a signed statement signed by the applicant saying that they do intend to leave the US at the end of their status. That doesn't prevent them from extending their status at the end of their visa. So they could, from within the US, apply through USCIS to extend their E2 status. It also doesn't mean that if circumstances change and the person becomes eligible for a green card down the road, it doesn't prevent them from applying for a green card as well. But again, it is very important to work with a qualified attorney because the government is sensitive to those applications. It's certainly possible to do that in a legitimate and honest and legal way, but the government is going to scrutinize that. So you do want to be careful as you navigate it. So let's visit what I mentioned before. And talk about what is probably the most common question for E2 visa applicants, which is how much do I need to invest? The government's language is that the requirement is that the applicant must invest a substantial amount of money. And they use that word substantial, but they don't provide a set dollar amount. So unfortunately, there really is no bright line test that says, okay, this amount is enough, and anything under that amount is not enough. That's simply not the way it works. And in some ways, that's a good thing, because what that allows is the possibility to advocate for businesses that have lower investment amounts. And actually, our firm specializes in helping people who don't have an especially large investment amount and really helping them to develop a strong application in spite of that. A good example is the one I mentioned before with the software company, and really looking at what other aspects of the application can be strengthened if the investment amount is low. But we do have some guidance on what is a substantial amount. The amount depends on the type of business that's being started and whether it actually requires a lot of money. Something like a law firm or a software company doesn't require a lot of funding, whereas a business where you're, say, developing a battery for an electric vehicle could require a lot more money to get started. And the government would want to see that those funds have been largely committed to the business. It also depends on where you apply. There are some consulates that simply tend to see larger businesses applying for E2 visas, and those consulates, not surprisingly, are more likely to reject an application with a lower investment amount. In contrast, there are consulates that are much more familiar with lower investment amounts. So one thing we do is work with clients to help figure out which which consulate is the ideal one to apply at. And finally, what I was referring to before is the overall strength of the case. So you can't look at the investment amount in isolation. You have to look at the entire application and, for example, look at how likely it is that the business is going to employ workers, and if they already do employ workers, and aspects of the case like that can make a lower investment amount less critical. The government does have what it calls a proportionality test, and this would apply to a startup. And what they say is basically the more money that's required to start the business, the lower the percentage of that sum, that total amount, is required to constitute a substantial amount. So to take an example, if you're starting a law firm or if you're starting a software company that really doesn't require a lot of money, let's say it requires less than $100,000, the government will want to see that 100% of that amount has been committed to the business. In contrast, if you're starting that business to research and develop and manufacture batteries for electric vehicles, Let's say that you estimate that that business requires $10 million to start up. The government is going to be more open to seeing that maybe 50% of that 10 million has been invested, or potentially even lower than that. But they're more open to the idea that you've invested only a fraction of the total amount, given that the total amount is so high. Now, with buying a business, it's a little different, obviously, because if you're buying a business that's on the open market, there's less of a question about whether you've invested a substantial amount, because presumably the market would price the business at what its fair value is, its fair market value is. One important aspect to keep in mind, and that Michaela will talk about a little later, is if you're buying a business from a family member, you do want to make sure that the transaction is at an arm's length. So it is an objective transaction that if the business were put on the open market, you really are paying your family member the same amount that you would be paying if they put the business on the open market. So do keep that in mind if you're considering that. But it's fine to purchase a business, and if you're able to show that the business was advertised to the public and you paid the amount that was advertised, usually that is enough to show you've invested a substantial amount. Similarly with a franchise, franchisors, so let's say you're opening, what's a good example? A Firehouse Subs. It's a popular sandwich shop here in the US. Let's say that Firehouse Subs, they as a franchisor are going to lay out what it costs to open a franchise. And if you've paid that amount, there's typically going to be little argument from the government that you haven't made a substantial amount, because the franchisor is going to define what it costs to start that business. Just a quick note, if a franchise agreement lays out that it should cost $120,000 to open a Firehouse Subs shop, and you've only spent $60,000 on that business, that could be a problem. And you'd want to explain why you haven't spent the full amount that the franchisor says should be required to start that business. And finally, common good and bad E2 visa expenditures. We talked about good ones before: inventory, equipment, website, marketing. Bad E2 visa expenditures tend to be money you spend to look for business opportunities in the US, whether that's spending money on hotels, spending money on flights, taxis, meetings with business associates, where you're meeting at a restaurant and you're putting the restaurant bill on your investment schedule. These are all things that the government doesn't want to see. And if you put it on your investment schedule, it could raise questions about why you're showing those expenses, and if you're trying to pad your investment schedule in some way. So best to leave those off. When I say investment schedule, really what I mean is a spreadsheet that lays out each and every expenditure on the E2 business. And that is something that we always prepare in our E2 visa applications, because it really does go to show the government not only how much you spend in total, but that, as I mentioned before, you spent money on all the things that are required for the visa. Do I have to hire employees? The answer is yes. You do within 5 years of the business being operational. This is called the marginality requirement. It is not necessary that you have employed workers before you apply for the E2 visa. It is okay to have a startup and to apply with a business plan that projects future hiring based on the anticipated revenue of the business. And in your business plan, it's also not absolutely necessary to hire workers in year 1 even. As long as you show that by year 5, you have 5 workers, that can be okay. We would always recommend, if you can hire earlier, do it. The government will want to see that. And don't save hiring for years 4 or 5. But if you need a year to ramp up before you hire your first worker, this can be okay, as long as you're showing that the business is going to generate revenue and that it makes sense, for the business to start hiring. Then again, if you're applying through USCIS and you have a business that is about providing direct services to customers, you want to be careful delaying hiring, because again, you need to be developing and directing the business as the E2 investor. Let's see. evidence if you W-2 employees versus 1099 workers. So a very common question is can I satisfy the marginality requirement by having independent contractors? The answer is you can. I think about it as a spectrum. The strongest is if you can show the government at least 5 full-time W-2 employees within 5 years of operations. That's best case scenario, because W employees tend to receive benefits. They tend to be more securely employed, longer term. Part-time W-2 employees are slightly weaker, though are perfectly fine in an E2 application. And again, you would just think about satisfying the 35 hours to meet that 3 to 5 full-time equivalent minimum requirement. But W-2 part-time employees are fine. 1099 workers or independent contractors are the weakest option, but frankly, if you have a business that tends to use 1099 workers and you plan for them to be long-term, like you plan to have an ongoing relationship with these independent contractors, that can be fine. And ideally, you would have more than 5 1099 workers. If you can find ways to add 1 or 2 W-2 employees, that's great. For example, an office manager, something like that, an assistant, that's good in addition to the 1099 workers. But again, it is possible to get an approval using only 1099 workers. How do you prove that you'll employ people? If it's a startup, use the business plan. If it's an existing business that you're buying, you'd want to show W-2 forms, pay stubs, and the company's tax return showing that this is a business with a track record of employing people. If you're buying a business that does not have a strong track record of employing people, you could be facing an uphill battle, because the government will ask, why hasn't the business employed people in the past? And why should the government believe that the business will start employing people if it hasn't employed people in the past? So you need to think creatively about what changes you'll make to the business to hire workers moving forward. Similarly, if you have a similar business abroad that hasn't employed people, you want to be careful with that, because the government will ask, why haven't you employed people at your business abroad that does something very similar? Why will your business in the US employ people? So if you're buying a business in the US, really look for a business that already employs between 3 and 5 US workers. And finally, business plan considerations. We touched on this before. A business plan is a critical part of the application if you have a new business, if you're starting a business, because it's really the only place in the application where you're going to explain to the government why your revenue projections are reasonable and why you believe you'll employ US workers in the future. If you don't have a business plan, there's really no good place in the application to convince the government worker that you're actually going to employ people. The business plan should contain all of the things you see on your screen: an executive summary. Oftentimes a consular officer will not get farther than the executive summary, so you want to make sure that those first few pages have all the critical information in it, including revenue and employment projections, in case they only spend 2 or 3 minutes with your application. You also want to include market analysis and research, a marketing plan about how you're going to generate interest and demand, a personnel plan showing how many people you'll employ over the next 5 years, a comprehensive financial plan showing your revenue projections and your profit projections. And finally, do you need to hire a professional? The simple answer is no, you don't need to hire a professional to prepare a business plan. However, the important thing to keep in mind is that it is not a business expert who's reading this business plan. It is a consular officer or a government USCIS officer, and they are looking at the business plan to see if it satisfies visa requiremms or E2 status requirements. So if you feel that you are able to speak to that audience effectively, then that is fine. However, we do find that it is valuable to have someone who can anticipate the questions that a consular officer or USCIS will raise, and to preemptively address that in the business plan. So with that, I will pass it off to Mick. Actually, I see a question that just came up. Do your services include writing a business plan? We do prepare business plans. If a client comes to us with a business plan, we will offer a high-level review of that business plan to make sure that it satisfies the E2 visa requirements. However, we do prepare business plans, and we'll work with the client on those projections if the client wants that. All right, so I will pass it off to Michaela to talk about some visa developments and adjudication trends.
Thank you so much, Dustin. Yeah, so let's discuss some recent E2 visa developments and adjudication trends. So what we have seen recently, especially at some consulates, is that, or some consular officers like to see that the majority of the E2 visa expenditures, if you are starting a new business in the US, were made in the US. So this is interesting because it's nowhere in the regulations. The E2 visa regulations don't specify that the E2 visa expenditures should be made in the US, but we have seen that some consulates especially like to see that at least some or the majority of the E2 visa expenditures were made in the US and not in your home country. So for example, if you are setting up a website, or if you are buying an equipment, office supplies, you should try to buy some of those in the US and not in your home country, and then ship them to the US. So then the second thing I wanted to mention is administrative processing. So ideally after the E2 visa interview, the officer would immediately tell you that your E2 visa is approved. But unfortunately, sometimes it happens that the officer will tell you that your case has to go into further administrative processing. And there are variety of reasons why your case may go into administrative processing. So sometimes the case may go into administrative processing because the government or the officer just needs more time to look at the file and make a final decision. And we have seen this a lot, especially since COVID started in 2020. So in 2020 and 2021, many consulates were issuing were putting cases into administrative processing because they just kind of needed, because they were backlogged and they just needed more time to look at the file and make a final decision. The case may also go into administrative processing because the government just needs some additional documents from you. So for example, if you were kind of preparing the file yourself and you just forgot to include something, or if the officer just kind of needs more documents from you, they may issue you they may put your case into the administrative processing and just let you know what documents they need and where you can email them or mail them to. And sometimes cases go into administrative processing because the government just kind of needs to do more security checks, and that happens as well. And when your case goes into administrative processing, the consular officer will issue you form, it's called 221G, and this is a technical denial of the application. But even if the case is in administrative processing, it may still be approved, but it's a technical denial. So if you are applying for an ESTA in the future, you would need to answer yes to the question whether your visa was ever denied, just because of the administrative processing. Another thing we have seen in the past 2 years is that more and more people prefer to file USCIS E2 change of status petition instead of going to the consulates. And this was mostly again when the COVID kind of started, and many people didn't want to travel because many countries required quarantines and things like that. Many people just prefer to file USCIS change of status petition because that way they could stay in the US and avoid traveling. And filing USCIS petition has its advantage and disadvantages. So one advantage obviously is that you can stay in the US. you don't have to travel. If you pay the government for the premium processing, you may have a decision on the case within 15 days. Ideally, in the ideal situation, your case would be approved within 15 days. I would say the disadvantages are that the change of status will only be approved for 2 years, and you have to renew it every 2 years. And then if you leave the US, you will need to go to a consulate and get a visa stamp. So the change of status kind of approval only governs your legal status in the US. And if you leave, you will need a visa anyway. Impact of the Biden-Harris administration. So we haven't seen, or there are no kind of like new regulations or changes in the regulations issued by the new administration. Even with the previous administration, kind of the E2 approval rate was always pretty high, just because the E2 visa, the visa creates jobs in the US. Even in the previous administration, as long as the E2 investor kind of met the E2 visa requirements, the visa petition was approved. So we haven't seen like many changes with the new administration. And then let's discuss some COVID-19 issues and E2 visa issuance. So testing. So you no longer need a negative COVID test to enter the US. And this is fairly recent. I believe the CDC kind of changed the rule a couple of weeks ago. But I will say you should always check the CDC website and double check what is needed, just because it can always change back. But as of right now, you no longer need the test, and then you still need to be vaccinated to enter the US as of right now, if you are a non-immigrant. Consular issues. So I will say that consulates all over the world are still a little bit backlogged since March 2020. Obviously, the backlog is not as bad as it was in summer 2020 or summer 2021, but it is still taking longer than it used to before COVID to get an E2 visa. And some consulates process the E2 visa petitions faster than others. So you would want to check what's the timeline at a consulate where you want to apply. Perfect. So now let's discuss some issues and complex areas that sometimes come up with E2 visas. So source and trail of funds. So Dustin kind of discussed this already a little bit in the beginning, but for the source and trail of funds, basically the government wants to see that the money you will be investing in the US does not come from a criminal activity. And if you are applying for an E2 visa at a consulate, the documents you have to submit to kind of prove this are, very kind of minimal. So for example, if the money comes from your personal savings, you would only need to submit your tax returns, and then you would not necessarily have to submit a lot of documents kind of showing the trail of the money from your personal account, business account, and from the business account showing how you made the E2 expenditures. But if you are changing status with in the US with USCIS, then we would definitely need to submit a lot of documents about the source and trail of funds, just because USCIS really wants to see kind of detailed documentation about the source of the money, but they also want to see the trail of the money kind of from your personal account and all the trail of money documents. So just one thing to keep in mind is that if you're kind of deciding whether you want to apply to consulate versus USCIS, is that USCIS will want to see very detailed documentation about the source and trail of funds. Now loans are fine for an E2 visa. You can take a loan, and that's completely fine. Just one caveat is that the loan cannot be secured by the E2 visa company. But other than that, loans are fine for the E2, and gifts are also fine for E2. So if your family member, friend, or whoever wants to gift you money to start or purchase the E2 business, that's completely fine. We will need to submit a gift letter, and then we will need to submit documents just showing what's the source of the money, of the donor's money. So for example, if the source is that the donor sold his house, then we will need to submit the purchase sale agreement to show where the money is coming from. Now, so what happens if the investment amount in your case is kind of on the lower side? So even if the investment amount is on the lower side, so let's say that you spent $50,000 and then you have additional $20,000 on your bank account, we would still want to kind of explain why the investment is substantial. So we would want to explain that even the investment is on the lower side, you really spend all the money that is necessary to start your type of business. So we would explain that you kind of purchased everything you need. You rented an office space, you bought an equipment, you kind of purchased everything you need, and you do not need to buy anything else to start this type of business. Also, if the investment is on the lower side, then we could also submit, business articles, kind of discussing, how much money usually has to be invested to start this type of business as an evidence. And also, if the investment is on the lower side, we do recommend that the other parts of the E2 application are strong. So if you only invested, let's say $40,000, we would recommend that, that you hire an employee, because that would be really helpful for the application. If we could submit contracts with clients or letters of intent, that would be very helpful for the application. And also your business plan should be really strong, and all the other aspects of the application should be very strong to kind of compensate the low investment amount. Now, can two investors get E2 visas? The answer here is yes, they can. Each investor has to own 50% in the company. And then each investor has to have a specific kind of high-level executive or managerial role in the company. So, one investor can be, for example, the CEO, and the other one can be CFO or Chief Product Officer, but each of you would have to have that kind of high-level executive or managerial role in the company. So now what happens if there are substantive changes to the E2 business after you got the E2 visa? So there can be two types of changes. So one is a change in the ownership structure. So let's say that when you got the E2 visa, you owned 100%, but now you want to sell 50% of the business. So that's completely fine. Just the important thing is that you always have to keep at least 50% in the business. But if you own 100 and now you own 50, you do not need to notify USCIS or consulate about this change. And then the second type of change is change in the type of business. So let's say, for example, that you opened a IT consulting business and you now want to open a restaurant. So, in that case, you would really need an approval from the consulate or from USCIS before you open the new business, just because the two businesses, the IT consulting and the restaurants, are very kind of like in unrelated fields. But let's say that you originally opened a restaurant and now you want to do some consulting in the food industry. So in that case, we could explain it as an outgrowth of the original business, and you wouldn't necessarily need to notify the consulate or USCIS until you filed your renewal application, in which case at that point you would want to mention this. But you do not need, in that case, you wouldn't need any prior approval to start the additional business. And so can you purchase a business from a family member? So Dustin already discussed this a little bit. So basically the answer here is yes, you can, but I will say that if the consulate sees that the business is being purchased from a family member, they will want to see kind of independent third-party evaluation of the business. Just to look at the evaluation, look at the price you paid for a business, to see, if you really kind of paid a fair market value for that type of business. And if you did, then it would probably not be an issue at all. But let's say that if the business was valued, the value of the business was like $200,000 and you paid $20,000, in that case, the case would most likely be denied. Perfect. So now let's discuss some common reasons for E2 visa denial. So one reason is that if you just didn't invest a substantial amount of money, if the E2 investment amount was low. So in this case, if you are willing to invest additional money in the business, then this can be relatively easy fix. Then you would just kind of spend more money, and we would submit the additional invoices and receipts and prove that you really invested this money in the new application. And we actually had many clients, where this was an issue, where client just kind of prepared the file himself or herself, and the investment amount was too low, and then they came to us, and we looked at the file, advised on what other categories or expenditures, what other expenditures should be made, and we resubmitted the application. And in many cases, the application was eventually approved. So yeah, if you are willing to invest additional money, this can be relatively easy fix. Then another reason for a denial is, sometimes it's just the nature of the business. So I will say that, real estate type of businesses are just kind of more scrutinized by the government, because in many cases, the government just kind of sees these type of businesses as passive investment and not kind of active E2 companies. So sometimes just the nature of the business can be an issue. Then sometimes what is an issue is the filing location or venue. So some consulates, like for example the US consulate in Toronto or US consulate in London, they are very familiar with the E2 visa requirements, and they are considered to be E2 friendly just because they're very experienced. But some consulates are, they don't get that many E2 petitions, and then the officers are not that familiar with the requirements. So sometimes if you file at a consulate like that, even though you may be kind of like meeting the E2 visa requirements, it may still be denied. So sometimes the filing location can be an issue. Then another thing is that if you already have a business in your home country and then you are opening the same type of business in the US, the officer sometimes asks whether the business in your home country has employees and how many employees it has. So let's say that you owned the business in your home country for 10 years, but you never had any employees, or you had one employee in the whole 10-year period, I would say that in that case, that can definitely be an issue for the E2 application, because the officer may just kind of question whether the E2 company will employ you as workers if the business in your home country wasn't employing employees. So if that's the case, you would definitely want to explain why the E2 company will hire workers even if the business in your home country, didn't need employees. Then another reason for denial may be, if the officer is just concerned whether the business will create jobs for you as workers. So, for example, if the revenues for the business are just too low, then the officer may just conclude that the business will not be able to employ employees. Then if you had any kind of issues in the past with adjudicating officer at a particular consulate, that can be a reason for a denial. And another reason for a denial may be if you just kind of didn't meet the requirements at the time of filing. If the file was just prepared poorly and the E2 visa requirements were just not met. Perfect. So now let's just quickly go over this last slide. What does it take to renew an E2 visa? So I will say that the absolutely most important thing when you are renewing your E2 visa is to show that the E2 company has employees. And as Dustin said, I would say 3 full-time employees at minimum by year 5 of operation. You would want to aim to have that at a minimum. If you have more, that's great, but minimum 3 full-time employees. And the salaries of the employees don't matter as so much for the E2 renewal. And some other things, the government wants to see when you are renewing the E2 visa, they want to see the company's tax returns, just so they can look whether and how much revenue and the company was making, whether the company was making a profit or not. But I will say that even if the company is not profitable and if it has small loss, as long as it's the revenue is kind of increasing each year, and as long as the company has employees, the small loss should not be such an issue. And I think we covered most of these other bullet points. So maybe let's move to the Q&A section, Dustin.
Sure. So thank you, Michaela. That was very informative. And I think actually we don't have too many questions. I actually think we only have 2. And I know we are running just a little bit late. I think that's my fault. I'm sorry I took so long on the first portion. But the 2 questions that came in, the first one is a very interesting question, asking about how same-sex marriages are treated for when an E2 investor applies and has a same-sex partner. And there is concern from this participant who's asking this question that maybe the Supreme Court will backtrack on its previous decision regarding the Defense of Marriage Act, in which essentially the government decided that there should be no difference in treatment between same-sex and different sex relationships. To my knowledge, and Michaela, let me know if you've heard anything different. I have not heard anything to make me think that the Supreme Court or the federal government are thinking about backtracking or reversing the same treatment of same-sex couples versus other couples. So I understand where the question is coming from, but it seems to me to be kind of a distant, very distant possibility. Obviously not impossible, but I frankly, and I think a lot of people would be shocked if we took a move in that direction. Is that your sense as well, Michaela?
Yeah, I agree. I haven't heard that they were planning to reverse the decision. Okay,
perfect. And then Michaela, I think this other question that came in is not specific to E2 visas, but maybe it would be helpful to get your thoughts on it. Marco asks what would be the path for someone with OPT, he's on an F1 student visa and is working on OPT, can he create a business and use it as leverage for a green card? Maybe it'd be helpful to talk about an E2 visa on OPT and maybe then a green card on OPT.
Yeah, I will say, so one option is definitely an E2 visa, and we had many clients who were here on OPT and then decided to switch to an E2. So E2 visa is definitely an option. I will say that many kind of students on OPT also apply for, or the employer sponsored them for an H-1B visa. So maybe that's definitely something like worth looking into as well. Just kind of asking your employer whether they would be willing to sponsor you for an H-1B visa. The next kind of time they can, the next opportunity they can do it is next March, so March 2023, unless you are working for like a university or NGO, in which case they could do it, anytime during the year. So I think, from like the non-immigrant visa options, H-1B, E2, possibly O1, just kind of depending on which field you work, but the O1 is you would need to already have kind of like achievements in your industry, so that would just depend. And with regards to kind of like switching, from the OPT to a green card. So yeah, I would definitely recommend maybe, scheduling a consultation, because kind of knowing which field you work in and stuff like that would definitely be helpful. But from the green card options, maybe the national interest waiver would be an option. But that's, again, like you will already have to have certain achievements for that. So probably just kind of going into E2 or H-1B first, and then possibly some green card category would be a way to go.
Perfect. All right, Michaela, thank you so much for taking the time and sharing your expertise. And to the participants, thank you so much for taking the time to join us for this webinar. We will be following up, as I mentioned before, with the recording, the PowerPoint, a link where you can sign up for future webinars, as well as a link to our YouTube channel, where I do encourage you to visit. We put a lot of time and effort into making good, high quality, free content available to you all. So please do check out our YouTube channel. Scott Legal PC is what you need to search for to find that. We do hope to see you on future webinars and hope you stay well in the meantime. Thank you so much.
Thank you, Dustin. Thank you.